Good morning. Thank you all for joining. Welcome to today's webinar, Negotiating Enterprise Agreements with Microsoft, sponsored by Scott and Scott LLP, an intellectual property and technology law firm located in Southlake, Texas, voted Technology Law Firm of the Year USA by Finance Monthly. Your presenter today is Managing Partner Robert Scott. He has been representing mid-market and large enterprise clients in high-stakes software license transactions and disputes for more than a decade. Rob has represented some of the world's largest companies in Microsoft Enterprise and cloud negotiations. Today's presentation will be recorded, and you will receive a link to it in the next few days. Please enter any questions in the question box, and Rob will answer as many as time allows. For those of you wishing Illinois, California, or Texas CLE credit, Diana Peterson will follow up with you later after the presentation. After the webinar, you'll receive a short survey requesting feedback on today's webinar and your ideas for future topics. We'd appreciate hearing from you. There is additionally a handout for California CLE credit applicants to fill out and return after the webinar. And now I'll turn it over to Rob Scott to start the presentation.
Thank you, Marcus, and thank you all for joining today. As Marcus said, today's presentation is on negotiating enterprise agreements with Microsoft. This is an area that I've been focused on now for over a decade, and so things certainly have changed in recent years, and we'll be going through some of the changes. For an agenda today, we're going to jump into the different licensing models and look at some of the changes from perpetual to subscription, and some of the licensing metrics, including user-based metrics and device-based metrics. And then we're going to jump into Microsoft 365 Enterprise to talk about Microsoft's newest online offerings. And then we'll get into the agreement types, the structure of the Microsoft customer, what I refer to as the MPSA, but some call it the Business and Services Agreement, the Enterprise Enrollments, and we'll also look at the Microsoft Product and Services Agreement, which is the MPSA, formerly known as the Select Agreement, for those of you who have been dealing with Microsoft licensing for a long time. We're also going to talk about the legal issues that we confront when we deal with negotiating enterprise agreements with Microsoft, and some of the strategies and techniques that we found successful over the years, including defining requirements. What I have found is that a failure to define the requirements up front leads to a lot of problems in the negotiations. In fact, many of the deals that I've worked on that appeared to have stalled out or gotten sideways, in every case, I can attribute some of that struggle to a failure to define the requirements up front. And so we work very hard with our clients to make sure that we provide to Microsoft all of the customer requirements in advance and provide them everything that would be necessary for them to give the client a full and meaningful proposal, including multiple options in terms of term, license types, etc., so that the client can fully understand all of the options that are available and make an informed decision with respect to how to proceed. We'll also talk about a term sheet. In fact, we have a term sheet available, and if you're interested in getting a copy of the Microsoft term sheet that we have available, you can contact me at the end of the program or email Diana in response to the follow-up emails that will come out following the presentation. But it's an excellent term sheet builder. It's focused significantly on cloud, and many of my clients have used it not just for Microsoft deals, but other deals with other vendors, because it does cover a lot of the key issues involved in cloud contracting. We'll talk about transitioning to 365, how to do that, how things to avoid when you're trying to transition to 365. That would be, if you're currently using productivity suites on premises deployments of Office, maybe you purchased it OEM with your hardware, maybe you have it under an enterprise agreement, but you're not currently in the cloud, and you're thinking about transitioning to cloud. We'll talk about how to do that and some of the incentives that may be available to you in order to do that, and how to evaluate the economics of those incentives. That will be an important business discussion for those of you who are looking to migrate to cloud. Limitations of liability is a very important legal concept when it comes to cloud. If you have been in enterprise agreements with Microsoft or other vendors where you're primarily deploying on-premises software where the vendor has no access to your systems and therefore no access to personally identifiable or other customer information, maybe limitations of liability wasn't a key term. But as you move from perpetual licenses to cloud-based licenses and you start dealing with privacy and security, business continuity, and other risks, limitations of liability become a central negotiating point when it comes to enterprise agreements with Microsoft and other vendors. We'll talk about true up. One of the benefits of the enterprise agreement is the right to true up periodically, and for certain products not to be out of compliance in the interim between true up periods. We'll talk about that. We'll talk about price protection and why that's important in cloud for Microsoft, but not only for Microsoft, all other vendors. We'll talk about business downturn in light of the pandemic, in light of what appears to be significant economic fallout. Business downturn provisions, I think, are going to make a huge comeback as we move forward. And what those do is they allow a customer to essentially resize the commitment in the event of an unexpected business downturn. Reduction in force could be a divestiture, could be other circumstances that where the quantity of licenses ordered originally are able to be reduced based on the triggering of a downturn provision. We'll talk about restacking. Restacking is a concept that is related to downturn in that it provides flexibility, but what restacking does, it allows you to reorganize your spend within the product family such that you can reduce your quantity of one product and increase your quantity of another product, provided that your minimum spend commitment stays the same. So that restacking is great for large organizations that don't fully appreciate what their deployments or needs are at the time of contracting, and a restacking provision can help eliminate some of that risk associated with not knowing exactly what you need right now or what you're going to need during the term. We'll talk about audit rights, including the notion of a high watermark, and something that I'm very concerned about with Microsoft standard language. We'll talk about regulatory compliance, including data processing agreements for GDPR, for CCPA, for New York Shield. Obviously, we're in an age of significant regulation of IT, and when you do a deal involving particularly cloud and personally identifiable information or personal data, the regulatory pieces are quite important. Over the years, I think Microsoft has done a very good job of keeping up with the regulatory compliance obligations of its customers, and is relatively, compared to other vendors, sensitive and easy to deal with when it comes to checking the box on things like data processing agreements, and generally we'll have folks on the deal team that have expertise in the various regulatory schemes, and I have found them to be reasonable and flexible when dealing with those issues. We'll talk about defining your affiliates for purposes of the enterprise and why that's important. We'll talk about some risks associated with acquisitions and divestitures, and we'll also talk about your rights to outsource to hosting providers for the software that you license under an enterprise agreement. So we got a busy schedule here, big agenda, and so we're going to get going, and hopefully I'll move a little bit quicker. So perpetual versus subscription. In perpetual, you're buying something, you're typically accounting for it as a capital expense. as opposed to a operating expense. It is the type of thing that you buy it, you install it, it's yours, and at the end of a term, for example, at the end of the term of an enterprise agreement for perpetual licenses, you have the right to the then most recently available version of that software, and you don't have to renew your enterprise agreement. You have the right to run that version forever, and so that's hence perpetual. The rights granted are they're not limited by time. You buy the license and you have the right to run it forever. The trend has been towards subscription for a number of reasons. One, subscription is an operating expense, not a capital expense. It is more flexible. You can make adjustments in your workforce. It floats up and down. With respect to cloud and hosted solutions, data storage and ownership of hardware, in the subscription models, the cloud-based models, the customer doesn't have to deal with owning infrastructure, building data centers, and the hosting, ownership of hardware, and delivery of the software are all bundled as an online service that's delivered through a subscription. But when you buy subscriptions and your vendor has the keys to your operations, and they could, in the event of a dispute, flip a switch and turn you off, it creates business continuity risks that aren't in play in the perpetual model. And as I said, much of what drove interest in cloud-based licensing models and software as a service-based subscription was the difference in accounting treatment between capital and operating expense, with many companies choosing, with respect to IT, a preference for OpEx as opposed to CapEx. One of the biggest changes that subscription has brought, particularly in the context of Microsoft, is the rise of user-based metrics. Historically, in Microsoft enterprise agreements, it was device-based for the most part, and you buy an operating system, you put it on a device. You buy a office suite, you put it on a device, and you could theoretically have multiple users per device, which was quite handy in certain industries. For example, I have many clients in the call center business where they've got multiple users per device. Also in the context of healthcare, you think about nursing stations and multiple shifts of nurses all, using one computer on the floor, but it's multiple users per device. In other contexts, you may have multiple devices per user. So think of my law firm. If you're a lawyer at my law firm, you've got a computer at home, you've got a computer at the office, you've got a laptop, you probably have some mobile devices, you probably have a tablet. And so in the law firm context and other professional services and corporate computing environments, it's likely that the opposite would be true, that you have multiple devices per user, and therefore a user-based metric would be favorable. For example, in some Microsoft licensing, you can, with one license, you can install the software for the same user on non-concurrent devices up to 5 times. So if you think about device versus user, it really depends on the nature of the use cases. And so we frequently had, this idea of like mapping users to devices. Previously, we'd be looking at, which way made the most sense. But as you get into large enterprises, and many of my clients are, Fortune 500 and very large global companies, what we found is that it's very difficult to identify the number of devices. Not as difficult to identify the number of users. Why? Because you have payroll, and your payroll records are pretty good records of users, and you got to keep them up to date. And it's an extremely solid system of record. And most of my clients, regardless of how big they are much better at counting users than they are devices. And while there may be a premium to move to user-based licensing, I would suggest that in most organizations, the software asset management burden of device-based models is significantly higher than user-based models, so much so that before Microsoft offered as many user-based metrics as they do today, I used to try to define what an enterprise device was as a device that was used by a user so that I could count users and not devices. Today, Microsoft offers 100% user-based models, but for the vast majority of my clients, we're still using a hybrid approach where we're device-based for the OS and user-based for the productivity suites. And we can get into that a little bit more later. So many of you have heard of 365. That's Microsoft's code name for their cloud-based offerings around productivity. But that suite of products is continuing to expand, and they have renamed the offering as 365 Enterprise. Used to be the Secure Productive Enterprise, or SPE. But the 365 Enterprise is an offering that bundles quite a bit of Microsoft technologies, and it can be device or user-centric subscription licensing model. And of course, it's got the Office suite, the Word, Excel, PowerPoint, Access, OneNote, etc. But also includes SharePoint and Yammer, includes Outlook and Exchange, meeting and voice with Teams. Also has some file sharing and streaming, as well as advanced analytics, including Power BI, which is a really cool tool that we've been doing some things with here, and I find to be very interesting and very powerful. And then importantly, the security and compliance pieces that many enterprises will require, that include encryption and threat analytics. And we feel that this is a smart move for Microsoft to bundle more value within the 365 suite of products to, really broaden out its cloud-based offerings and to bundle them in a way that is attractive for many of the enterprise customers. It will increase the stickiness, we think, of Microsoft's customers, and it really covers a lot of the core IT needs for many customers. Interestingly, the switching cost to move away, the broader the technology, the more that's in the bundle, the harder it is to move away, and therefore, without some of the contractual provisions we're going to talk about later, this really puts more leverage in Microsoft's hands, for renewals and post the initial terms than in the customer's hands. So while it's quite an extensive bundle, it also will make it difficult for customers to migrate away after they sign up. So let's talk about the structure of the Microsoft licensing agreements. A lot of, like with all of IT, it seems like a lot of acronyms. And I think this chart will make it easier for you guys to understand what these acronyms are and how they relate to each other. So the MPSA is like a master level agreement. It contains, core terms and conditions that are not subject to change. You can't buy anything under it. There's nothing to order. It is truly a master level agreement. If you have a master in place, then the next level is the program level. And the program level for a lot of customers will be the enterprise agreement or the EA. And again, this is the program. It's the category of license. It's the licensing scheme that you're going to be ordering under. Again, you're not going to order anything with the enterprise agreement. You're going to do that at the next level down in the ordering documents. And when you're in an EA, your ordering documents will be an enterprise enrollment. That would be for perpetual licenses. The enterprise subscription enrollment, that would be for either subscription-based licenses or cloud-based licenses. And then the SCE, which is the server and cloud enrollment. And you don't need the server and cloud enrollment. We have a lot of clients, for example, that put their SQL Server and other server products in the enterprise enrollment or subscription and don't use the SCE. And then we have others that define that the savings associated with the SCE are favorable to them. It's something that when I talked about, having multiple pricing options, that would be one of the things that we would recommend for clients is to price the enterprise agreement, one with an SCE and one without it, and see how that works. The MPSA is an agreement that is a volume licensing program. It doesn't require the size of the enterprise enrollment, which I believe at this point is a minimum of 500 users or devices. So if you're under that amount, or for whatever reason you don't want to buy software assurance on all of your licenses, which is required as part of the enterprise agreement, then the MPSA would be the open license agreement terms that you would use. And it is a volume license that basically has some reductions in price for volume. And then also we have the online subscription agreement, and that's going to cover your online services. That would be all of the cloud-based offerings that Microsoft has. So this is the structure. When you're working on a deal, you're going to want to make sure you get all of these agreements from Microsoft to the reseller as early as possible. These forms change pretty frequently, and a lot of times what will happen is Microsoft and the reseller will drib and drab these agreements to you and lay them on you, at the very last minute with limited time for review and negotiation of potential changes. I will tell you that with respect to the MPSA, those terms are frequently non-negotiable. We've had very limited success in negotiating MPSAs. However, the enterprise agreement and its related stack for clients of our size and sophistication are typically extensively negotiated as part of either a new enterprise deal or a renewal that is bringing significant cloud adoption. So what's in the online subscription agreement? It's going to have the online terms. It's going to talk about acceptable use policy. And most importantly, it's going to contain the security commitments. The security commitments are critically important because as a regulated entity, almost all of the federal regulations involving IT are going to require you to do a risk assessment and due diligence on all of your vendors, including Microsoft. And the disclosure of the vendor security commitments is a critical part of that due diligence. And so when we work on deals involving Microsoft and other vendors, we work very closely with our clients' internal security experts to carefully review the security commitments, to understand how those security commitments compare to the policies and procedures of the customer, to evaluate with respect to specific use cases, whether or not the security commitments contained in the online services terms are equal to, greater than, or less than the security measures that are in place related to the data in question today. And so a thorough examination of the security commitments, probing of the parameters, clarification of what they mean is critically important to discharging the due diligence requirement of your own security obligations when performing vendor due diligence. And we spend quite a bit of time on the online subscription agreement focusing on those security commitments. The enterprise enrollments are where you get into actually looking at, how are you going to build out the solution? Are you going to do per device, or are you going to do hybrid? So the hybrid, as I said, most of my clients are doing hybrid where they count devices for OS, and for productivity suites like Office, they're doing, and CALs, they're doing user-based. So that's what hybrid means, a hybrid between some products are device-based and some are user-based. So you got to look at what kind of CALs you need, what CAL suite you're going to want to be looking at. You're looking at Windows upgrades. All that would be part of what you'd need to configure in your enterprise enrollment. The enterprise cloud suite is going to be that per user focused approach where you can even get your Windows SA per user. And you've got the enterprise mobility suite and the 365 enterprise, and all of that is licensed on a per user basis. And it's conceivable that you'd have, if you went in that direction, you would need no device-based licensing. And very attractive. In the deals that I've looked at, the premium for this for my clients that have looked at it was higher than what they were comfortable with, and they, for the most part, have gone with that hybrid approach that I described earlier. So the server and cloud enrollment is great for some clients. The difference is it's a enterprise-wide commitment. So if you want, if you're comfortable that you're going to have all of your server products on your enterprise agreement, and you're going to have all of your server-based licenses to carry software assurance, then the server and cloud enrollment carries with it a pretty significant discount on a per SKU or license basis. The downside to it is for some clients, the enterprise-wide requirement becomes costly and not a good fit for how they're built out in terms of their infrastructure. But this would be another one, as I said, get it priced both ways and see if the savings of the SCE outweigh the enterprise-wide obligation. The MPSA is, again, the volume license agreement. Some clients will have a EA for some things and buy other things under an MPSA that kind of rides along with it. As I said, this replaced the select agreements. Now the MPSA is a unified master agreement and program agreement, meaning you don't need an MPSA to ride above the MPSA. All you would need to enter into is the MPSA on its own. It's based on a point system. There's no minimum at the outset, but you have to purchase a minimum of 500 points or cloud services for at least 250 users within each active product pool in order to maintain purchasing eligibility at level A. one of the downsides for large enterprise of the MPSA is that it's not standardized across the entire enterprise. You can run into issues with compliance and software asset management. Again, the EA model is a lot more flexible, and it offers things that the MPSA does not. But there's no payment commitment on the MPSA. It still will allow you to purchase, the Microsoft Online services such as 365 and other cloud offerings. So it's not the case that if you want to be in 365, for example, that you need an EA, because you can do that under the MPSA. And the MPSA will allow you to work with multiple resellers under a single account, where the enterprise agreements are through a designated reseller. Switching gears a little bit to some of the strategies that we use in helping clients negotiate deals. Defining the requirements is critically important, and understanding certain things as you go into a deal will help you significantly in terms of your outcomes and the efficiency of the deal itself. And one of the biggest things that I think complicates enterprise negotiations is the customer's compliance status. If there's a significant compliance issue, whether it is something that is revealed in the context of an audit or something that maybe the customer knows about but Microsoft is not fully aware of, but is concerned about, significant compliance issues going into a negotiation can be a very complicating factor in getting an EA deal done. And so one of the first things that I'm going to want to understand at a very detailed level in working with a client is, what is the client's effective license position? What are its software asset management practices? What type of sophistication in terms of data and reporting? How recent is the reporting? What kind of completion and completeness and accuracy testing has been conducted to really get an understanding of what is that effective license position? Where are we with respect to any compliance issues? And how strong will we be able to present our license position to Microsoft in a way that will give them comfort that the counts that we're putting forward are true? And if you can't get to an agreed state of facts with Microsoft or any publisher for that matter, it's difficult to move a deal forward. And so counting and compliance issues are critically important to understanding where you are with respect to your requirements. Also, what are we using now? We may be able to see what's deployed, but how much of what's deployed is being used? If we've got certain bundles of products and they include a variety of different SKUs, are people using them all? Could we, for a high percentage of our users, could we go with a lower cost product that doesn't include one or more of the components of what's currently deployed? How will our needs be changing over the next 3 years? Are we planning to migrate to the cloud over that period of time? What extent will we be migrating to the cloud? And so understanding sort of where we are with what's in use and what we anticipate will be used going forward is critically important to defining the requirements. What are your goals currently? What are your goals now? What are your near-term goals, and what do you see operationally in 3 years? What are your financial considerations? Do you need to spend less money than you've been spending? Are you open to spending more money, getting more value? What is it from a financial perspective that is important to communicate? And then the legal terms. What are your priorities? Like, we're going to go through a lot of different issues, and you may look at some of them and say, that really doesn't apply to my business. Others of them, you'd look at them and say that would be critical for me. That would be the most important thing that we could negotiate. And so really understanding and laying out up front, in the requirements document, the key legal priorities, if that's limitations of liability, if that's the right to have transition services, if that's the right to true up all products as though they're EA products, whatever your legal priorities are, we like to communicate that way in advance. That's not something that we like to spring on them, after the deal has been fully priced, negotiated, and then, the agreements come, they get sent to us, and we redline them, and all of a sudden, all of these new concepts are being raised for the first time. I do not recommend that approach. I recommend on the key legal pieces, getting those on the table up front as soon as possible. And in my experience, even if you don't get agreement on them up front, the fact that those are on the table and have been clearly communicated, I think is critically important. We like to prepare actually a PowerPoint presentation, and we give our clients a template, to work off of. And we actually recommend that a PowerPoint be put together and shared with Microsoft and the reseller to clearly communicate the requirements. Whether it's a renewal or a new deal, here's our slide deck on, what are our talking points, what are we trying to accomplish, what's important to us, here's our count, here's our product mix, here's our goals, here's our legal term priorities, all up front in the form of a PowerPoint presentation. We have found that is a very effective way to enter into the negotiations. Once we go further into the deal, and we have received a number of proposals, and we're moving now toward a deal, and we know sort of what the products will be, and we know what the program will be. Then we start working to build a term sheet, and the term sheet is really valuable, not only for Microsoft, but in any enterprise negotiations, because the stacks of paper just are very large, and it's difficult to communicate to the stakeholders in a clear and concise way what the issues are that are being negotiated and what the status is on each of those issues if you've got to thumb through red lines of hundreds of pages of documents. Well, with the term sheet, you have a relatively manageable size document that can really provide a clear and understandable view of what the language is that is under negotiation and what the progress is on the negotiation. So we use the term sheet to guide the negotiations over the contract changes, and it's extremely valuable. We often identify our proposed changes in the term sheet, and it identifies the contract section. So it'll say this is in the MPSA, and this is the language that we're concerned about, and this is our proposed language. And then there'll be comments for, why we're asking for this, what our explanation is for the ask, what the business reason or legal reason is that we're asking for it. And then as we move through, we can keep track of, what the status of each of the requests is. And we often will color code the term sheet as we go through so that the items that are resolved will be green. The items that are in discussion but not fully resolved would be yellow. And the items for which we can't reach agreement will be coded in red. And you can start to see as the negotiation, evolves, kind of what progress is being made as we move through. We generally will exchange it back and forth. It becomes a document that is kind of exchanged back and forth, and ultimately the language that is negotiated in the term sheet gets memorialized in a custom terms amendment. So we frequently don't redline the actual documents that Microsoft sends, although different people at Microsoft have different preferences. And the vast majority of the deals we work on, we don't redline the documents. We go from the term sheet to a custom terms amendment that then includes the negotiated language from the term sheet. We recommend using the term sheet for all enterprise customers negotiating enterprise agreements with Microsoft, but also in any significant deal involving cloud or software as a service. We think the term sheet is great, and we have a version of it that's available to participants on the call, and my assistant Diana can provide it to you, or you can email me, and my contact information will be on the last slide at the end of the presentation. So many of my clients have looked to transition to Office 365. They like the idea of cloud-based offerings. They don't want to be in the hosting business. They've come to believe in many instances that the privacy and security that's offered by Microsoft is better than the privacy and security that they can provide on their own, or that their current hosting provider or managed service provider is providing. And so it's appealing on a number of levels. It's attractive in terms of the way it's licensed. It's OpEx instead of CapEx. You remove the requirement to have hardware, and it's a simple solution. So a lot of clients over the years, and still many more to come, will be migrating to 365. If you think about the impact of the pandemic and the need for more people to be working from home and remotely, I think that all plays quite well into cloud-based offerings generally, and specifically for Microsoft. What you got to look at when you transition is you probably already have some stranded investment in the Microsoft Office products, and you need to evaluate what that investment is, how old the licenses are, to what extent there's remaining software assurance, if any, and you're going to want to negotiate to recapture some of that spend. In many instances, you may have recently purchased a substantial quantity of the same version that you will be getting into with 365, and you don't want to buy the same software twice. And so that's a concept that Microsoft clearly has heard from other customers and is sensitive to, and therefore they will provide some financial incentives, concessions, et cetera, to allow you to migrate. We've seen that take the form of transition SKUs or delayed payment dates, or just straight dollar concessions off of the enterprise enrollment price. But capturing that stranded investment in Office as you transition to the cloud is an important aspect of negotiating an enterprise deal. Limitation of liability is a provision in the contracts that talks in terms of the customer's ability to recover damages in a lawsuit from Microsoft. If Microsoft, for example, is negligent and your data goes missing, what will be the customer's ability to recover damages, and that will be limited by the limitation of liability. And the typical limitation of liability for most cloud deals is something like you can recover 6 or 12 months of the service fees that you paid for the service giving rise to the incident. And that's a pretty weak limitation from the standpoint of the customer, the probability that the customer could be made whole for its probable claims with a limitation liability crafted like that is relatively low. And what I like to do with clients is say, let's look at some probable claim scenarios. You know, what if your data goes missing? How many records will it be? What will be involved in, you know, giving notices? What will the impact on the business be? Will we have to hire a crisis management firm? Will we have to do credit monitoring? And start looking at what types of dollars are likely to be involved in those claims, and then do a calculation. You know, this limitation of liability says we get X months of service fees. What are the service fees? And if we take 6 months or 12 months of that, how much does it add up to? And does that sound like it will be enough? And in many instances, the answer is no. The other thing to think about with limitations of liability is there are frequently carve-outs. The carve-out would be the identification of a claim or claim types that are not subject to the cap. For example, it's common in deals with Microsoft and other vendors that claims regarding IP infringement are not subject to the cap. It's also common that claims for intentional and willful misconduct are not subject to the cap. Sometimes we'll want violations of the security commitments to be not subject to the cap. But when you're negotiating for a customer a limitation of liability, you want the carve-outs to be as broad as possible. I mean, you want to carve out as many of your probable claim scenarios as possible. Another one that's commonly carved out is the party's indemnity obligations. So the carve-out may read, except for intentional misconduct, IP infringement claims, and claims related to the party's indemnity obligations, the vendor's liability under this agreement shall not exceed XYZ. So the carve-out is usually in the preamble to the limitation of liability. The other thing to think about with respect to limitations of liability is that it's common in Microsoft deals and all software deals that the parties will agree that neither party will be able to recover indirect or inconsequential damages. And in most jurisdictions, indirect and inconsequential damages include lost profits and business interruption, and might include certain claims related to privacy and security. And so it's very important when you're dealing with cloud-based deals to very carefully review the boilerplate limitation of liability on indirects. Because you may, for example, want to have a clarifying paragraph that says, notwithstanding the foregoing, the following types of damages shall be considered direct for purposes of this agreement. And you can include, for example, business interruption, downtime for the application not working. We frequently will include privacy and security related damages from data breach to make it clear that, the types of damages associated with a data breach, to the extent that could otherwise be argued to be indirect or inconsequential for purposes of the agreement, shall be considered direct damages and therefore recoverable and subject to the cap or carved out, depending on where you land on that. So again, it's critically important to negotiate the limitation of liability. I generally will leave this to last. I like to hit the limitation of liability at the end. And so frequently when I'm negotiating with Microsoft, we'll have a disagreement on this point, and we'll agree to disagree and see if we can make progress on the other issues and come back to it. And this is one that should be done close to the end, because it's hard to really fully appreciate what you'd be willing to accept unless and until all the other aspects of the deal are fully negotiated. So leaving this one to last can be a good strategy. But we spend a lot of time on this particular issue, and I think for good reason. True-up terms. The true-up is a construct of the enterprise agreement that allows you each year to go and count what you have, and to the extent that you have additional deployments of licenses, to place an order to bring your license quantity in line with your deployments. One of the issues that is in the true-up language in Microsoft's more recent deals is this notion of maximum usage levels of additional products. And I refer to that as a high watermark. And I have made the argument on many levels that nobody can really count this. I mean, short of doing an inventory every day, it would be impossible for a customer to know what the maximum usage level was. And I think this language was added because there were a lot of customers that had cyclical businesses that timed their EAs and the true-up timing so that they were truing up at a time period where in a seasonal business they had the lowest quantity of deployments. And Microsoft added this language to make it clear that in a seasonal business where you have a wide variety of deployments, you can't just true up at the end of your term and buy only the minimum level at that time and essentially game the system that way. But for everyone else that wasn't cheating, this high watermark concept is incredibly onerous. I don't know any clients that can meet it with accuracy, and it's something that we generally push pretty hard on to negotiate away from the high watermark. It's something that is extremely onerous and fraught with the potential for compliance claims in the context of audits. Price protection refers to provisions in the agreement that limit the vendor ability to increase prices both during the term and for renewal terms. And we recommend negotiating a cap on pricing increases at least for the first renewal term, and perhaps even longer, depending on the size of your business and the nature of the switching costs and the level of financial commitment that you're making. I think it would be foolish for anybody to get into a deal where they're moving into somebody else's cloud for a 3-year period and not have some visibility into what the renewal price will be at the end. Because at the end, in subscription agreements, you have no rights. So it's not like you could say, hey, look, I don't want to renew. I'll just stay with what I have, because at the end of the term, you have nothing. And now you're there at the end of a contract term. You're fully dependent on the vendor. The vendor has all the leverage in the situation on price, and they may have given you a really good deal to get you in for 3 years, and then next thing you know, you're looking at 20% or more price increase at the end of the term. And that is not a good position to be in. And so we recommend that price protection be heavily negotiated on all cloud-based deals, including with Microsoft. Business downturn is something that I used, in 08 to 2010 time period, where many of my clients were facing uncertain economic times and wanted to do deals but wanted some flexibility. These are custom provisions that we've written that basically allow the customer to negotiate for reductions in the enterprise product counts in the event that there's a downturn, whether that be measured in terms of a reduction of revenue as a percentage or a reduction in force in a certain amount. Having these protections help to mitigate the risk of having to purchase products or services for users or devices that may be removed during the term. You've got a 3-year term. You may divest half your business in that 3-year term. You may have a 20% reduction in force. And the last thing you want to do is be stuck with a bunch of software or services that you don't need. And business downturn provisions accomplish that. And I think, as I said earlier, in light of the pandemic and the related economic uncertainty, I think that we're going to see a lot more of need for this. Restacking is a concept that I developed years ago when I had clients that needed to do a deal quickly but didn't have their counts together. It basically allows you to stack what you're buying in terms of the quantities of each product, provided that what you're buying is equal to or greater than the value of the initial order quantities. And usually it's done within the first year, and the unneeded quantities can be replaced with other products that are needed more than, for example, what we anticipated going in. Important to look at audit rights. We generally, having a background in software audits, and as many as we've done, we're pretty focused on negotiating audit rights. Obviously, the vendor is going to have some right to audit. For some, extremely large clients with really good relationships with Microsoft, it's possible to, get some forbearance of audit. It's harder and harder to get as time goes by, but negotiating more favorable audit rights. In fact, even, for example, negotiating to be not, drawn out of a hat, to require some reasonable suspicion. All of these things are ways to reduce your audit risks and not spend the money and time associated with defending audits when you're in an enterprise agreement. We talked about regulatory compliance. I find that Microsoft is good at this, but the onus is on the customer to understand which pieces they need. It becomes very important when you're dealing with hosted environments. In addition to GLBA and HIPAA, which are large security and privacy regimes in the United States, GDPR is becoming very important for many clients, as is California CCPA. The New York Shield was just recently passed, and others are involved. We have a lawyer on our team, Stephen Pinson, who's a certified privacy law specialist. And when we work on EA deals for clients, we bring him onto the team to focus just on the privacy and security aspects of the deal. It's important to understand how the affiliate and licensee terms work with Microsoft. You want to make sure, for example, that everyone that's using meets this 50% ownership threshold. And some of our very large clients do businesses globally. They may operate businesses that they don't own 50% or more of, and that can be a real big problem in the context of Microsoft licensing. And if you have that situation, that's something you need to negotiate up front in terms of defining the enterprise and what the affiliate definitions are. We do a lot of work, and you'll see in our term sheet builder, around improving the base agreements capacity to deal with acquisitions and divestitures. We recommend custom amendments, specifically targeting M&A activity, things like the ability to provide access to a divested entity for a period of time for transition services. We represent a lot of hospital systems where, one business may buy a group of hospitals from another business, and all of the electronic records are still going to be hosted by the seller for a period of time. And without a transition services agreement in your EA, that's not something that's easy to do. And there's not an easy way to license that without a transition services agreement. So these are, number of custom amendments that we develop related to M&A activity. And as I said, many of our large global clients are very focused on M&A. And in light of the pandemic, many believe that there will be an increase in M&A activity as liquidity continues to be an issue in financial markets. Microsoft recently has implemented changes to the product terms that restrict how customers' licenses can be used to support deployments at certain large-scale service providers, including the large public cloud players, Alibaba, Google, Amazon, and Azure. Software assurance coverage is now required for all such deployments. It's not going to matter in an EA deal because EA deals all have SA. But it's important to understand, how these outsourcing deployments work. If you're using, public cloud and you're wanting to bring your own licenses to public cloud infrastructure, it's very important that you understand how the licensing works, and could be a significant impact on this, and something you want to make sure that you're addressing in your negotiations. We also have done cloud migration provisions that allow you to turn down licenses, for example, that were previously on-prem and move into hosted environments through a migration strategy, which is essentially allows you to reduce your quantities as you migrate. As Marcus said, there's a question tab over on the right-hand side of the panel, on the GoToWebinar panel. And what I would ask you to do is enter your questions there, and we will endeavor to answer them all and respond to you via email. And for those of you who are interested in receiving the term sheet builder for Microsoft, you can either call the office at 214-999-2902 and ask for Diana and give her your information and she'll send it to you. Or you can feel free to email me at rjscott@scott&scott.llp. And with that, I'd like to thank you for joining, and we look forward to having you on another presentation in the near future. Thank you.